A quiet ruling from the highest court didn't just nudge gun policy. It rewired the way gun cases live, breathe, and sometimes die inside courtrooms. The strange part is that this rewrite has already reshaped several major legal battlefields, without most gun owners realizing it happened. Before we go any further, let me ask you something simple. Do you usually stop at headlines, or do you look underneath them? Because what I'm about to explain is exactly how people end up trusting the wrong summary and walking straight into a legal mess without meaning to. Take a breath and stay with me, because this is not about hype. It's about how the rules changed when most people weren't looking. For the past few years, the loud conversations were all about permits, bans on certain rifles, or the latest announcement from a federal agency. Those stories matter, no doubt, but the bigger shift happened somewhere quieter. The court didn't just weigh in on one type of law. It changed the method judges use to decide almost every gun case that comes before them. Think of it like this: the scoreboard didn't change, the entire rulebook did. That rulebook shift came from a case involving a state carry law that once required ordinary citizens to justify why they deserved to carry a handgun in public. Under that old system, you didn't just apply and pass checks. You had to convince an official that your personal reason was good enough. Maybe you worked late. Maybe you lived in a rough area. Maybe you'd been threatened. It didn't matter. Unless the official agreed with you, the court finally said the system crossed the line. Carrying a firearm for self-defense in public fell within the core protection of the Constitution. Regular people weren't required to audition for a right. Most people stopped listening right there. They celebrated the permit win and moved on. But buried in that same ruling was something far more powerful. The court didn't just decide one issue. It told lower courts to stop using the old balancing test they loved so much for years. Judges had followed a two-part routine. First, they'd ask whether a law touched the Second Amendment at all. Then, if it did, they'd weigh the law against the government's stated interests, usually public safety. In practice, that meant judges often upheld restrictions simply because they believed the government's reasoning sounded reasonable. The high court told them to cut it out. No more interest balancing the way it had been done. Instead, courts were instructed to focus on the actual text of the Constitution and the nation's historical tradition of firearm regulation. In plain language, that means if the government wants to enforce a modern gun rule, it now has to show that the rule fits within a pattern of regulation that existed in early American history, not a carbon copy, but something close enough in purpose and burden to make sense in the historical context. That sounds abstract, academic, and painfully boring. It sounds like something that only matters to lawyers who argue for a living, but it has very real consequences for anyone who owns, carries, builds, transports, or even just stores firearms and related gear, especially if you don't want to become the unlucky example in someone else's court case. So let's slow this down and make it useful. I'm going to walk you through several shifts tied to this new legal framework and its ripple effects. Some look like victories, some look like losses, some look like nothing happened at all. And ironically, the ones that look like nothing happened can be the most dangerous, because they convince people the law is settled when it's not. The first shift is the one everyone thinks they understand. Public carry permits changed nationwide, but the danger didn't disappear. It moved when the court struck down discretionary carry systems. Every state that relied on officials saying yes or no based on personal judgment was suddenly on shaky ground. Those systems became legal liabilities, so states reacted fast. Some cleaned up their permit processes. People cheered. They assumed the fight was over. It wasn't. Some states simply changed tactics. Instead of blocking permits, they expanded lists of places where carrying a firearm is forbidden. These areas are often labeled sensitive locations. The idea itself isn't new. Even the court acknowledged that certain places, like schools or government buildings, have historically been treated differently. The problem came when that concept got stretched beyond recognition. After the ruling, some states treated sensitivity like a magic word. They applied it to such a wide range of locations that the practical result looked a lot like the old system, just wearing a new costume. You might hold a valid permit and still risk serious charges by stepping into the wrong place without realizing it. Picture a normal day. You leave home, stop for fuel, grab coffee, pick up a prescription, swing by a school office, mail a package, then meet someone for lunch. In your mind, you're compliant. You did everything right. But under some of the post-ruling laws, the problem isn't your permit. It's the invisible boundary lines between where you can carry and where you can't. Now imagine all of that happening inside a single shared building. A medical clinic on one side, a daycare in the corner, a government service counter near the entrance, a cafe, and a small bank tucked in the middle. Would you always know which side of the hallway you're standing on legally? Would you know whether stepping 10 feet to the left changes your exposure from lawful to criminal? Most people wouldn't. That's not carelessness, that's reality. This is why thinking that carry reform fixed everything is a mistake. The battlefield changed. Some states complied openly, others complied strategically, and for everyday people. That means the risk now lives in maps, signs, and definitions. The second shift surprised many people who assumed the new test would wipe out every restriction. It didn't. A case involving firearm possession during certain domestic court orders clarified how the historical test actually works. The federal rule at issue temporarily bars firearm possession for individuals under specific court orders tied to findings of threats or violence. Many expected this rule to fall under the new framework. It didn't. The court upheld it, and in doing so, it explained something critical. History and tradition don't require exact matches from the 1700s. They allow analogies. The court pointed to older laws that disarmed individuals deemed dangerous or likely to cause harm. The focus wasn't on the object, but on the risk posed by the person. This corrected a misunderstanding that spread quickly after the earlier ruling. Many people assumed the test meant that if a law didn't exist in identical form centuries ago, it must be unconstitutional today. That's not how the court sees it. Laws that are targeted, temporary, and tied to specific findings of danger stand on very different footing than laws that are broad, permanent, and disconnected from individual behavior. Think of the difference this way. A rule that temporarily disarms someone after a court finds credible threats is one thing. A rule that permanently strips rights based on a distant or unrelated event is another. The court signaled that these distinctions matter a lot for gun owners who care about the long game. This matters because future cases will likely turn on scope, duration, and process, not slogans, not outrage. Courts will examine whether a rule is narrowly focused or sweeping, whether it's tied to real findings or assumptions, and whether history supports that kind of burden. The third shift had nothing to do with the Second Amendment at all, and that's exactly why it should make you uneasy. A case involving a controversial accessory turned on statutory interpretation, not constitutional rights. The question wasn't whether the accessory should be legal. It was whether a federal agency had the authority to redefine it as something Congress had already banned under existing law. The court said the agency went too far. The law Congress wrote defined a banned category in a specific way, and the accessory didn't fit that definition. If lawmakers want it banned, they have to say so clearly. Agencies don't get to stretch words and tell ordinary people become criminals overnight. That sounds comforting, and in a way it is. But look closer. The real danger for most people doesn't come from dramatic bans announced on the evening news. It comes from quiet changes in definitions. What counts as a firearm? What counts as a receiver? What counts as automatic? What counts as readily convertible? Those phrases are where lives get complicated fast. Imagine buying something that is legal today. You keep records. You follow instructions. You do nothing reckless. Then an agency announces a new interpretation. Suddenly your lawful item is classified differently. You're told to surrender it, destroy it, or face penalties. Even if you never intended harm, even if you acted in good faith, you're now exposed. The court's message in that case was directed at agencies, but its impact reaches much further. It affects how future rules are written, challenged, and enforced. And it reminds everyone that definitions matter more than most people think. The fourth shift pulled builders and hobbyists deeper into regulated territory. A case involving unfinished components and build kits resulted in the court allowing broader federal control than many expected. Certain parts and kits can be treated as regulated firearms depending on how they're designed, marketed, and sold. This wasn't a sweeping declaration that homemade firearms are illegal everywhere. That's a myth. The truth is far more detailed and far more dangerous for people who don't pay attention. Federal rules, state laws, and classifications interact in ways that are easy to misunderstand. If you enjoy building, customizing, or buying components online, this is an area where ignorance can turn into serious trouble, not because of bad intent, But because categories shift, something treated like a piece of metal one year can be treated like a controlled item the next. The fifth shift is the one people struggle to accept. The court did not rush to settle fights over certain high-profile bans and limits. In several instances, it declined to step in. That doesn't mean approval. It means timing, records, and strategy matter. But the practical effect is that lower court rulings stayed in place. That creates a patchwork. One state enforces one set of rules. Cross a border and everything changes, and because high court review can take years, those differences persist. For people who travel, that's not theoretical. It's immediate. Picture packing for a trip with gear you've owned for a decade. You're not thinking about the magazine in a side pocket. You're not thinking about local limits. You're thinking about traffic, hotels, family. Then a routine stop turns into questions. Questions turn into seizures. Seizures turn into charges. Even if you win later, the cost hits now. Or picture walking into a building that looks like every other place you've been. Depending on local rules, the default might be no carry unless explicitly allowed. That flips expectations upside down. Everyday life becomes a guessing game, and guessing wrong can be expensive. All of this leads to one uncomfortable truth. The biggest change wasn't one law being struck down or upheld. It was uncertainty, becoming the norm. The rules now depend heavily on where you are, when you are there, and how current the last update was that you read. So what do you do with that? First, stop trusting one-line summaries. When you see a headline about a court decision, ask what kind of case it was. Constitutional, statutory, agency authority. Those distinctions decide how the outcome affects you. Second, understand that the historical test is an engine, not a destination. It will keep producing new results. New rules will be challenged. Some will fall. Some will survive. Details will matter more than ever. Third, remember that courts are drawing lines based on risk, process, and scope. Not every restriction lives or dies the same way. Future cases will turn on facts and procedures as much as philosophy. Fourth, treat travel like entering a different legal system, because in many ways you are. Your responsibilities shift the moment you cross a line on a map. Fifth, stop thinking in terms of permanent answers. Think in upgrades, deadlines, and changes. Laws move. Interpretations shift. What was safe knowledge last year might already be outdated. The quiet truth is this: the court didn't just touch gun law. It changed how gun law is argued, defended, and enforced. Permits, possession, parts, places, and definitions all live under a new structure now. If you care about staying lawful and protecting the people you love, you can't rely on vibes or hearsay. You have to understand the system that decides what legal even means from one year to the next.